SJC-11824, Commonwealth v. Jason Douglas, and another.
Okay, Mr. Katz.
Thank you. May it please the court, my name is Daniel Katz, and I'm the attorney for the co-defendant, Wayne Steed. I will be splitting my time with my brother. If the court has any questions, I'm certainly prepared to rest on my brief in terms of the waiver issue concerning the affidavits. If there are no questions, I would love to proceed to the unconstitutional search and seizure.
Do what you love.
Thank you. In terms of that, Justice Greene said that the order of events is critical in cases such as this one. And I like to think of these cases in terms of a film, and if we look at each event or each observation of the officer as a movie still and see, does it add up to what they have to get to, which is the reasonable suspicion that their safety or the safety of others. And if we look at...
Can I just interrupt you
Sure.
for a second there? Do you agree that Judge Sanders said that actually they needed to do two things with respect to the frisk part, at least? They needed to not just be concerned about safety of themselves and others, but also that there had to be a reasonable suspicion that crime was afoot. Do you rely on the crime was afoot portion of this at all?
No, I rely on the fact that Judge Sanders was correct, both where the exit order and the pat frisks were illegal and the police involvement should have stopped there based on the fact that they did not have a reasonable suspicion for an apprehension of danger to their safety or to the safety.
So to the extent that she relied also on this notion that there had to be crime and is it reasonable suspicion that crime was afoot, you don't say that that's a second requirement.
No, Your Honor.
Okay.
Yeah, the part that I'm struggling with most is his two colleagues are outside the car, having been frisked, maybe in the process of being frisked, and he moves the car into park, ostensibly to leave them behind. That's a rather extraordinary thing that somebody feels the need to, from the passenger seat, move the car into park.
No, into drive, it must
Into
be.
drive, I'm sorry, into drive. Well, so what inference is appropriate from that?
The inference appropriate from that, and if I would implore upon Your Honor to also remember that the car did not move.
I understand that,
Yeah.
but he did take the step of moving it from park to drive.
Right, and then he did comply when Officer Hawkins said, put the car back in. So.
And I take it throughout the car was on? The engine was on? Nobody just said, turn the engine off?
There is nothing in the record that I'm aware of that, first off, Officer Hawkins did not do what he is supposed to do in a routine traffic stop in terms of failure to use a directional signal, which is go first to the driver and ask for a license and registration.
Yeah, but I think that there was some indication that Johnson, who was Johnson right behind?
Yeah, it was Johnson was.
And Johnson was the one that was moving right away to the and that he was immediately, as he was going to the driver's side of the car, that he was distracted by that, and that's what caused him immediately to.
Wasn't there some problem about where the car stopped also? That it was dangerous to.
It was near the Jersey barrier, but in terms of Your Honor's question, that in and of itself may have been an apprehension that he might put the car into drive, but it does not, nor can one reasonably infer that that means that there were weapons or any apprehension of danger to the officers. So that is one consideration, just like the consideration of his prior firearm offense. And back to your Justice Lank's question about Johnson, who was the first one that did catch his eye. And if you look at all the cases from this court, there has to be a movement described as either reaching for, concealing a weapon. Here we have Officer Hawkins say, well, he shifted or turned his torso towards the middle of the car. There is nothing that a reasonably prudent person in his shoes could say that there was any reaching for, concealing, ducking out of view. All these cases, even Stampley, in which the only factors are the ducking, but the ducking happens twice. In every case that this court has found that the officers have reached that the constitutional requirement of reasonable suspicion for their safety or the safety of others, there has been some kind of movement ducking out of view, and that was not the case with Johnson. And in fact, when Hawkins says, well, I guess he turned out to be drunk, and maybe he was reaching for the seatbelt. But in and of itself, there's nothing.
In and of itself, along with the fact that Officer Hawkins knew a lot about Johnson.
He knew about Johnson, but...
So had reason to think that maybe Johnson had something else he was doing besides going for a seatbelt.
And even if you say, okay, there you go, you get that one, officer, this court has said, use the terms initial concern. Okay, so that's some initial concern. But then you have when Johnson gets frisked, nothing. My guy, Steed, whose behavior is described, and I implore your honors to look at the transcript where Hawkins says, well, he just stood forward and he was not acting like a priest, doctor, or a nun, therefore that was unusual. And yet there are plenty of cases in this.
But there was also that knowledge, again, they knew something about, Hawkins knew something about your client, and also had been told by another police officer, wasn't it, Sullivan, about the guy was clutching his pockets in a way that worried them that there might be guns being carried.
That is not...
Still clutching his in the back seat when he was looking straight ahead. Now, I grant you looking straight ahead is not exactly suspicious necessarily, but, you know, if you don't want to catch somebody's eye because you think you have a gun in your pocket, it might be.
And this court has plainly stated that it's a normal reaction from someone who is stopped by the police not to want to look the officers in the eye. Plus, if you recall, or I ask you, Your Honor, to look at the judge's findings where she didn't credit what Sullivan said because he had not testified. But even so...
Discredited. She just said she didn't know.
That is true. But even so... maybe that gets your another initial concern, but then the fact that all four occupants are pat-frisked and nothing, no holster, no ammunition, nothing, no shots in the area, no reports of calling to a shooting nearby. So even if, and this court has mentioned this term initial concern, that still doesn't meet the constitutional requirements. I see that my red light is on, so I must concede to my brother. Thank you.
Good morning. Michael Tomposki on behalf of Jason Douglas. I want to just quickly address Justice Lank's question that you asked towards my brother about the standard. And I actually disagree with him slightly. I believe that in order to justify a search in this situation, the police must have reasonable suspicion that there is criminal activity afoot, that the suspect is armed and dangerous, and in this case, that evidence of that danger will be found inside the car. So it's actually a three-pronged test.
That's a Terry stop analysis. I mean, here, the police officer has made a legitimate motor vehicle stop.
Yes.
And the analysis of what the officer needs to consider in determining whether to ask the passengers and driver out of the car and pat frisk them aren't reason to believe a crime is being committed and the individuals are armed and dangerous, is it?
I believe that where the stop shifts from a traffic stop to what turns into clearly an investigatory stop, yes, there must be some evidence that there's a crime being committed and that suspects are armed and dangerous.
I mean, as I read it, and I always thought this was the law, to support an order that a passenger alight from a vehicle and maybe even undergo a pat frisk, the officer need only point to some fact or facts in the totality of the circumstances that would create in a police officer a heightened awareness of danger that would warrant that officer in securing the scene in a more effective manner.
I believe, and I'm sure, I believe that that's the standard for an exit order, not for a frisk and a frisk of the car. That's my understanding.
But if you have
of the
that
law.
belief that there is some danger in connection with this stop,
Yes.
that does not justify a pat frisk, only an exit order? So
This
you got 'em
court
out
has
of the
actually
car.
held in a couple of different cases that facts which may justify an exit order, and I believe Torres, which I said in my brief, is one such case, facts which may justify an exit order do not necessarily justify a frisk of that person, or even beyond that, a frisk of the car that the person was an occupant of. So the standard necessary to satisfy an exit order is not the standard necessary to satisfy a search of the person and a search of the car. That's a more heightened standard. And I think the standard set forth in Commonwealth v. Martin, although that was a stop on the street, would apply in this circumstance as well. It must be reasonable suspicion that the individual is armed and dangerous, and that evidence of that danger will be found inside the car.
But the evidence of that danger, I mean, this is a protective sweep designed to essentially be a frisk of the car for weapons.
Yes.
I mean, the officer here was entitled to stop the vehicle, correct?
Based on the facts found by the judge, yes.
And when an officer is entitled to stop a vehicle, an officer is entitled to take reasonable steps to protect his or her own safety, which means that during the course of that stop, if there is any reasonable concern that they may be armed and potentially a threat, aren't they allowed to take action to protect themselves?
If it's a reasonable belief, absolutely. And they did take some action here. And so there's three key moments. There's the facts that they knew prior to frisking Steed and Johnson, the facts that they knew after frisking Steed and Johnson, and then whether Douglas's behavior adds anything to the mix. And what they knew prior to frisking Steed and Johnson was that Steed had his hands in his pockets. Johnson supposedly reached towards his seatbelt, and they knew that Johnson and Douglas had a criminal record. What they knew after frisking Steed and Johnson was that Steed's hands in his pockets and Johnson reaching for his seatbelt were in fact nothing. So any suspicion about those facts had been completely dispelled by the pat frisks that the officers undertook. And what they were left with at that point was simply that they knew a couple of the people in the car, and they knew that these people had been at a party where other people with records had been at the same party.
And then your client, unbidden, got out of the car. He's a big guy, and they say he's acting like they know him, and they've had plenty of time to assess him, and he's acting oddly tonight. And they say that they worry when somebody gets out of the car in any event. He's busy trying to deal with the other people. They're worried when that happens because somebody could be armed. And so they order him back in the car. He gets in the car, and no sooner does he get back in the car than he puts the car from park into drive. They're standing in a position where if the car actually took off, it could have hurt them. They would have been fleeing. It's not nothing.
I understand that, and I would say a couple things to that. First, as to the issue of him getting out of the car, where I point this court to the Torres case, 424 Mass at 159, where the court said that in the context of a normal traffic stop, which this was initially, although they never actually asked for the driver's license and registration, this was a traffic stop, that it's not unusual for a passenger to get out of the car to greet the officer. And importantly, when asked to get back into the car, he immediately complied. Now, as to the issue of putting the car from park into drive, I would say two things. One is the judge found that it was a non-issue because the car didn't move. But secondly, what risk does that create to the officer? It creates the risk potentially vis-a-vis movement of the car. So perhaps the officer would be concerned that the wheel would run over his foot or something to that effect. So what is he justified to do if he's concerned that the wheel might run over his foot? He would be justified in telling the driver to turn the keys off, get out of the car, telling the passenger, turn the keys off, or simply just to get out of the car. What does that tell us about whether or not a weapon would be found in the car? And my position is that although obviously it may justify some action on the part of the police, what it doesn't justify is searching the car, because that behavior tells us nothing about whether or not there is a weapon inside the car.
Well, what is it? I mean, one could make the argument, and you can respond to it, that when somebody is eager to leave the car and is told to go back in, and that there may be a reason for that, and then he goes back out, he's frisked, he finds nothing on him, and then when he gets back in the car, he takes a step consistent with trying to leave and leaving two other passengers in the car behind, that there may be a reason for him to do that. And since he had a prior firearms conviction, that the possibility of another firearm being found in the car was sufficient to cause him to seek to flee. I mean, that would be, one could argue that to be the inferences.
Well, I understand that that's what the Commonwealth is arguing and what the appeals court seem to rely on. But my position is that that simply doesn't give rise to an inference that there is a weapon inside the car. Just to take your point, perhaps it would give rise to an inference that there's some contraband. Maybe, I'm not even necessarily conceding that. Stolen property, drugs even. But stolen property and drugs in those circumstances wouldn't justify a search of the car. It has to be a weapon. And so, based on the evidence that the police knew at the time, his behavior, even factoring that into what they knew before, and also subtracting what was dispelled from the frisks of Steed, Johnson, and Douglas, simply doesn't give the police, in that circumstance, a sufficient basis to justify searching the car.
Okay, thank you.
Thank you.
Good morning, Your Honors. If it please the Court, Donna Petalino on behalf of the Commonwealth. Sitting with me at council table is Joe Janasic, the Assistant District Attorney and Chief of our gang unit, who represented the Commonwealth at the motion hearing. When you look at this case, what my brother says about the movie is important to keep in mind, except here you would have to have multiple cameras at once, because the judge simply parsed out the actions in a subsequent fashion that just is not realistic. When Officer Hawkins and Officer Wozni approached the car after it had been stopped for failure to signal, things unfolded quickly to both of the officers. Officer Wozni came up on the driver's side. Officer Hawkins came up on the passenger's side. Johnson reached over to the middle. They already knew from Sergeant Detective Sullivan that Steed had clutched his pocket for his hoodie as if he were holding the weapon. That was the message that was
So these are all
transmitted.
findings that were made by the
Yes, Your
judge.
Honor. And the judge.
And how much are you relying on additional findings that supplemented those findings made by the appeals court when you are laying out what the moving camera was?
I am relying
Cameras.
on those.
You are relying on those, that's what I...
Right. Well, there's quite a bit. I would say that Judge Sanders made all of the findings that we can rely on, and the appeals court really fleshed out those findings according to the testimony. So there wasn't anything that the appeals court found that hadn't been found.
Can it be called fleshing out if it is inconsistent with her conclusion? I mean, everybody's relying on Isaiah, but Isaiah didn't adopt additional findings. Isaiah says if it's not fleshed out, send it back.
Well, Your Honor, I don't think you need to send it back here. When you look at the testimony, the appeals court explained in much more detail about the party at the nightclub that these people came from. But it was all in the testimony that was below. It was uncontroverted testimony.
Well, it's always uncontroverted, isn't it?
Well,
I mean, there's only police officers testifying, and so the trick is, what is the judge believing in this always uncontroverted testimony given by police officers about what happened, and what is she not crediting?
I'm not sure that she certainly didn't make any adverse credibility determinations here. she didn't even draw any adverse inferences here. But what she did do was I believe she neglected to really give full credence to the context of this stop. And the context of the stop is that it was a surveillance car that Hawkins and Wozni were in. They knew quite a bit about the people that were in this car. So despite my brother's reliance on Torres, Torres is completely different than this case, because in Torres, the officers didn't know the passenger. They were stopped for a speeding violation, completely different than having encountered a person 50 times prior to the stop, and understanding. He even said, hey, get back in the car. He used his first name when he told him to get back in the car. It's significant that these officers know these men very, very well.
So that's significant even in the absence of any evidence of a crime. You just know who they are.
Well, first of all, he knew them because of crimes that they had committed. That's on the record. And
Not the ones that they're being...
Not committed that night,
Right.
but committed previously.
Okay.
They knew that they were members of a gang or affiliated with members of the gang. They knew they were coming from a gang party where they were celebrating a gang video that had gotten 100,000 hits on YouTube.
Is that all included in Judge Sanders' findings?
Judge Sanders talked specifically about the video, that the video was... The party was a celebration of the video, that in the past, viewings of those videos or the viewing of videos had led to violence before. So this is like a heightened
Here's the thing,
crime
though.
area.
Historically, we've been very clear that judges' findings can be disregarded if they're clearly erroneous.
Yes.
And they're clearly erroneous if they are not founded in the evidence. Nobody's suggesting that Judge Sanders' findings were clearly erroneous. Every finding she made was grounded in the evidence. The question is, as to the other evidence as to which she did not make findings, and we've always been very clear, too, that it's the trial court, the motion judge's job, not the appellate judge's job, to make credibility determinations. And what's concerning is this is a backdoor way of getting at she did not make the right credibility determinations here because she didn't take into account other evidence.
I think it's
And so
more
that's
about
where I
weight
think
than
that
it
some
is.
of this is coming from.
I'm sorry, Your Honor. I think it's more about weight than it is about credibility. It's what to emphasize in order to justify the end result that the motion judge makes.
I don't, because you're basically saying she didn't come to the right conclusions factually because she didn't take all the right facts into account. There were these other facts, and she sifted through them, and she came up with the facts she came up with, and not others. But she should have. She should have weighed those things in the balance.
Well,
not that she was clearly erroneous. There's a distinction.
Yes, there is, and that's why Isaiah is so important. Because when you look at the totality of the circumstances here, in Judge Sanders' findings, it's simply parsed too finely to really acknowledge what happens to these officers when they make stops. We were reminded of that 10 days ago when an officer was shot making a car stop very similar to this. Same unit, the Youth Violence Strike Task Force. But when she parsed it out and to say, subsequent to this happened, as if it happened in a particular, very finite, distinct order, it just isn't the way that it happens. And this court and the appeals court have said multiple times that it just can't be parsed out that finely. The justification for the exit order and the pat frisk doesn't have to be on an immediate threat, but on this totality of the circumstances that there's some reasonable suspicion for an apprehension of danger. And there is very much that in this record, whether you rely just on Judge Sanders' findings or whether you supplement it with testimony.
You're basically saying if a judge doesn't specifically say, I discredit, that we're going to just assume that she credits everything that a witness says?
I wouldn't say that necessarily, but I think you could certainly put a different weight onto the facts that she credits. What she found is not necessarily, the weight that she gives it is not necessarily the way that really gives credence to what happens to these officers when they make stops, and why there is a lower burden when you're making a exit order and a frisk for an apprehension of danger.
Would you say the burden for a frisk after an exit order is essentially the same as the burden for the exit order?
Yes, I would, Your Honor.
And the further so-called frisk of the car, is that also the same, or is there something a little more that is required?
No, I think it's the same. And the whole purpose of the frisk is to confirm or dispel the apprehension of danger. And there are instances where you could dispel the apprehension of danger based on the pat frisk, but there needs to be an affirmative dispelling of that apprehension of danger.
But I get the idea that from her own findings, I don't think you have to go outside, that the car is stopped and various of these individuals, I mean, each of them does something that, let's just accept that every single one of them, it's perfectly legitimate for exit orders and a pat frisk of them. Having done that, when there's no evidence before from the sergeant, detective, or did I say that right? I always.
Yes, you did, Your Honor.
Okay. There's no evidence from the sergeant, detective, or anybody that they left with. I mean, so.
No, Your Honor, there is evidence from Sergeant Detective Sullivan, that Steed is clutching his is.
So you think that's it's that we're looking for?
Both that and Douglas's actions in punching the palm of his hand, saying that he wanted to. She didn't find that. She did say that he was agitated, though, and what you could base the agitation on is that he wanted to leave that parking lot, and the inference that you could draw from that, or that the officers could reasonably draw from that, is that there was going to be a confrontation based on what had happened at Felt and based on the videotape.
Yeah, but
and the gangs.
What we're doing, they've done a stop because of a red light. Aren't we checking about reasonable safety for the officers? Isn't that what is justifying this?
They did the stop because of the failure to turn.
Right.
And
a failure to signal.
And once knowing what they know, all of the information about Douglas and Johnson, knowing how Steed had behaved and Douglas had behaved, and how they were continuing to behave during the stop, that there was this apprehension of danger based
themselves.
Yes, but
the officers.
You're not suggesting they could have just pulled the car over without a motor vehicle violation?
No, absolutely not, Your Honor.
No, but I thought what you said before, it was suggesting to me that they could apprehension of prospective danger because they were going somewhere and going to have an interact. That's not what you mean, is it?
No, absolutely not, Your Honor, and I apologize if I confused the court. Really, it was that the officers understood that there was the way that the evening had unfolded, and the record that these people had, the interaction that they had, particularly with Douglas, also with Johnson, the firearm convictions, the 50 times that they had seen them beforehand, and then as they're approaching the car, which was legally stopped, seeing that reach by Johnson, knowing that Steed is the one that they're concerned about having the weapon because of what Sergeant Detective Sullivan had seen in the parking lot beforehand, all of that together creates a reasonable apprehension of danger that allows for the exit order and then the pat frisk. When the pat frisk reveals nothing, that dispels nothing. That nothing is revealed.
So the reasonable apprehension of danger, in your view, is basically Steed because of the sergeant detective's.
And then Johnson,
I don't mean to be sounding negative. I'm just asking: is that what it is?
Yes, absolutely.
Is it that gun? It's that or that whatever you
You can't parse that away from all of the information that the officers knew about these particular people in the car and what they had done in the parking lot beforehand.
Sorry, but Judge Sanders made no finding of what they had done in the parking lot beforehand.
She did not, Your Honor, but.
So that's all the appeals court adding findings to what Judge Sanders
Which is
found.
allowed under Isaiah A.
No, it's not.
Why?
If it's implicit that the judge credited it, but how do we know that the judge credited what they said they had seen?
Well, she certainly doesn't make an affirmative credibility determination.
Which often is the case. And Isaiah, just to back up on Isaiah, there were erroneous findings in Isaiah, and it was remanded back. There was no fact-finding by an appellate court.
But there's no charge here that there are, that even the inference that we're asking you to draw from the transcript would be erroneous. So it's even less of what was asked in Isaiah I. It's what the officers testified to. And remember, this is an objective belief of what a reasonable officer in their shoes would understand all of this to mean. The officer testified, and the judge made no adverse credibility determination. So I think that this court should feel comfortable in supplementing those findings.
If we don't do that, if we rely only on the findings that the Judge Sanders had made, can we come to the same conclusion as the appeal court?
Yes, you can, Your Honor. Absolutely. Given the officer's knowledge, and Judge Sanders did make findings about this, particularly about Johnson and Douglas, that when Officer Hawkins was coming up on the passenger side, he also saw Steed clutch the front and stare straight ahead. Douglas was acting.
I know about the stare straight ahead. Is there a finding that
he was holding? I am almost sure, Your Honor,
okay.
but
All right,
have to
that's fine.
double check the
You can
record. I apologize. Certainly, there's a finding about Johnson reaching over, and then Steed and Douglas being completely different in reaction to the officers than he typically was. And Douglas doesn't jump out of the car when Hawkins is finished pat frisking Steed. He jumps out as the pat frisk is going on, and he yells, "Jason, get back in the car." That's how well this officer knows Douglas.
So where did Judge Sanders go wrong after she made her findings?
I think it's a weight issue. I don't think when you look at her findings, it's too much parsed out in subsequent actions. This happened, then this happened, then this happened. And the Commonwealth agrees that all of those things happen, but it happens fast, and it just cannot be parsed out in a way that it does sequentially by Judge Sanders.
Judge Sanders was also saying that she thought that there needed to be a reasonable belief that there was crime afoot.
Right, and that's wrong.
And so to what extent was that legal error that you say was legal error influential in what she did?
I think it's significant in what she did, and that's one of the reasons why I think it would be very easy to vacate this suppression order, and when you discount that analysis that she gives.
And Judge Sanders was probably also entitled, although she made no finding, to say this car was not stopped because of a failure to make a turn signal. They stopped this car for the purpose of conducting a frisk.
It doesn't matter, Your Honor, because objectively it was stopped for...
Well, I understand as a matter of law it does not matter, but isn't she permitted to consider that in evaluating the police justification with all the things they said they saw which justified a frisk, to perhaps be a little bit skeptical whether all that happened, and therefore her silence... We should be careful about accepting that her silence concerning facts presented by the police were necessarily accepted by her.
Well, that's certainly one way that you can look at it, but you can also look at it that the officers knew these people well. And one of the reasons why they were watching to make sure that they were obeying the law is because they knew them as people who don't obey the law, and to stop them and make sure that they do obey the law. And as they were doing the routine traffic stop, regardless of whether or not they were waiting for that a violation of the law to happen, the violation of the law did happen, and that makes it permissible for them to pull them over, the driver to pull over, and as these two officers are approaching the car, that is when the apprehension of danger arose, and it certainly was well within the officers' ability to exit those people out of the car, pat frisk them, and then to shine the flashlight as a light pat frisk of the car.
Thank you.
Thank you, Your Honors.